Have the individual at the jail please provide your first name for me.
Greg Gray.
Okay, and is your date of birth June 7th, 1969?
Yes, Your Honor.
So this is a preliminary appearance based on alleged new law violations. You're entitled to certain constitutional rights. At this point in the process, the focus for this court is on your right to remain silent, your right to have an attorney. Mr. Graham, I ask that you sit back so that we can see your face on the video. Thank you. And to have an attorney appointed to represent you at public expense if you qualify. In reviewing your screening form, the court finds that you do qualify for court-appointed counsel. For today's hearing, that's going to be Mr. Jenkins, who's appearing via Zoom. I'm going to hear from Mr. Jenkins regarding the state's probable cause statement. And then I'm going to hear from Mr. Larivold from the state regarding his request for release conditions. Mr. Larivold is appearing via Zoom and is also in the courtroom with me. And then last, I'll hear from Mr. Jenkins regarding argument on your behalf as it relates to release. Mr. Jenkins, anything you wish to say at this time?
We'll reserve any objection at this time.
Court will find probable cause for the alleged crime of theft in the first degree, $500,000 or more. Mr. Larivold, go ahead, please.
Thank you, Your Honor. And in looking at the nature of the alleged offense, yes, the state understands that it is a property crime, but looking at the nature of the alleged incident causes the state significant concern underneath whether he would reasonably appear that without bail, that it would reasonably assure his appearance. And the state also has concerns that he may otherwise intimidate witnesses or otherwise unlawfully interfere with the administration of justice based on the nature of what was alleged to have happened. The state would point out that there's been 8 felony FTAs in the defendant's criminal history, and I know the defense counsel will argue that there's been none in the last 2 years, but still he has shown a repeated sort of course of conduct about a failure to appear when ordered by the court. There's been 26 total misdemeanor FTAs, so a total of 34 failure to appears. And I know the defense counsel will argue that there's been none in the last 2 years, but 3.2 just indicates whether or not it would reasonably assure his appearance. It doesn't talk about timeframes, and the state would argue that it would not, without bail, wouldn't reasonably assure his appearance. The state would also argue that he's a flight risk, as it's indicated that he was traveling between states during the course of what was alleged to have occurred. So the state has concerns about whether he would flee the jurisdiction. The state would also point out that in 2005, the theft of government property in federal court, he was convicted of similar sort of dealings in federal court, dealing with unlawful possession or taking of trees. There's been attempt to elude, there's been protection order violations. There's been failure to return rental property, failure to comply, criminal impersonation, FTR after written promise to appear. So the state does have significant concerns in this case. The state would be asking that bail be issued in the amount of $75,000, that he not have any contact with the alleged victim of what's alleged to have occurred, Tammy Stanton. They did not also have contact with Philip Lapp or Terry Sutherland. That he report to pretrial services within 2 days of release. That he not violate the criminal law, not leave Washington State, and not possess any dangerous weapons or firearms. Thank you.
Mr. Jenkins, go ahead.
Yes, Your Honor, we'll be asking that he be released on his personal recognizance. And no, Your Honor, I'm not going to mention anything about he hasn't had any FTAs in the past 2 years, because his last warrant was from 1997. So it's been a lot longer than the past 2 years. I noticed that the state didn't mention the dates on those charges, because the majority of his charges worth mentioning are over 20 years old. He has a lot of driving offenses, Your Honor, but anything significant is over 20 years old. So 3.2 does mention about recency, Your Honor. And so we'd like the court to take that in consideration. We don't believe he's a flight risk just because he's left the state. Anyone that takes vacation leaves the state. His address is here. And I will actually tell the court that, come on, slow computer, that he's a lifelong resident. His address has always been here. Yeah, Your Honor, that's really the basis of our argument. And it's just based on the fact that a lot of this stuff is extremely old. I do understand the allegations, but it's very hard to say someone, in our opinion, is a fair to appear if the last warrant's from 97, and that they're any type of threat when this case, as the court knows, the allegations are based off of agreements and other types of dealings. So we'd like the court to take into the fact that he's not a substantial threat to commit a violent offense or fair to appear. There's no evidence of any history of any type of witness tampering or any threats of that nature. So we don't believe he's also a threat to interfere with administration of justice, Your Honor. So that's the basis for our request.
Thank you. Enforcement order that he not leave the state of Washington, not commit any criminal law violations, not possess any dangerous weapons or firearms. He is to have no contact with Terry Sutherland, Philip Lapp, as well as Tammy Staton and Lori Berryman. He's to report to pretrial services for their supervision within 2 court days of release. Their contact information will be contained on page 2 of the release order. As it relates to the request for bail, the court does note that the history is somewhat dated, but somewhat extensive. There's 34 FTAs. There's failures to comply, obstructing public servant, failure to comply, attempting to elude, protection order violation, etc. So noting that the prior convictions are somewhat dated, looking at the nature of the allegations before the court today, the court would find that there is not a less restrictive alternative than imposing bail based on a likely failure to appear, as well as likelihood that he would unlawfully interfere with the administration of justice. The court is going to set bail in the amount of $10,000, cash or bond. He is to return to court on March 15th at 9 a.m. for arraignment. That will complete this hearing.
Thank you, Your Honor.
Your Honor, was there an attorney appointed in that case?
Yes. I'm sorry.
You need a